Thank you everybody for joining us this evening for our event on the Justice Working Party report, When Things Go Wrong, the Response of the Justice System, which is our most recent report published today. I'm Jodie Blackstock, I'm the Legal Director at Justice and oversaw the Working Party's work on this report, which was led by our Senior Legal Fellow, Robbie Stern. For those who don't know about Justice, we are a human rights and law reform organisation working to improve access to justice across all areas of the justice system, and we do that through our membership of legal academics, lawyers, judges and other people interested in the justice system, and largely through working parties of those members and invited guests. So this working party is one of a number of working parties that we have on the go at any one time, and we're delighted that this particular working party was able to sit so ably over the past year under the chairmanship of Sir Robert Owen, with many incredible members, including Ken Sutton, and you'll see all of their names in the front pages of the report, so I won't go through them all now, but we were incredibly pleased with everybody who wanted to be involved in that piece of work. So we offer all of our thanks for the time and dedication to those members. The Working Party itself was an idea that the chair of the Justice Board, Walter Merricks, was able to persuaded isn't the right word, but we certainly agreed with him that it was an area of work that needed careful attention, and we spent a number of months looking at how a working party might cover this area. It's a very complex one indeed, and you'll hear from Sir Robert in a moment about how we went about that work. I would like to just offer some thanks in relation to how the work was put together before we kick off, because not only was it those members of the Working Party, it was also our corporate partner that enabled us to take this work forward, Morrison Foster, and we're delighted that they were able to do that. Certainly for the first half of the work, we were indebted to them for the use of their office space and for their thorough research, which supported us in our work, and to all of the members of the team there, which are listed in the back of our report. We're immensely grateful. We've managed to conduct the second half of the work by Zoom meetings like this one, and pull it all together through this new video format. But we do hope that we'll all be able to join together again at some point when we are able to do that safely. Particular thanks must go to Robbie Stern, who I'm sure is here somewhere in the attendees, for all his incredibly hard work, marshalling through and steering through this work, despite the difficult times of doing that during COVID, and it would not be the report it is without his effort, and we wish him very well as he starts his pupillage at Matrix in a week, 2 weeks now. So to take us on then, and I should also just thank all of the people who we spoke to during the course of that work. The consultees are listed there at the back, and there's particular people who put in more time and effort than others. One in particular is Pete Weatherby, over the issue of duty of candour. But you'll see all of the people that we spoke to there, and we're grateful to all of them for sharing their time with us over such a complex area of law. So if I move on to this evening's event, I'm very pleased to all of the panellists we have here this evening to speak with you. So Robert, as I mentioned, chaired the Working Party for us, and that comes after a long career looking into inquiries as a barrister first, but then as a High Court judge, and in particular with the Litvinenko inquiry in 2016, which I think provided lots of food for thought and experience as we went through this piece of work. We're very pleased that Jason Beer QC is here with us as well from 5 Essex Court. I know that Robbie spent a lot of time going through your book over the course of this to assist him on understanding how the system operates. So we're very grateful to you, and also to Allison Munroe QC from Garden Court, who both have an immense amount of experience in the areas of inquest and inquiry. So we're delighted to have you with us today. And finally, Ken Sutton, who is the director of the Hillsborough Panel, and has gone on since to be involved in a number of areas looking at how we can better respond to systemic failure and state actions which lead to death in areas of concern. So I'm incredibly grateful to all of you for spending the time this evening, and I'm sure that our attendees will have many questions for us over the course of the evening to share. So just before we kick off, a little bit of housekeeping for our attendees. The event is being recorded, though you of course won't be seen on that recording. We won't share the recording of the questions and answers session because we don't have your permission to use your names or questions in this. So rest assured, anything that you ask during that part of it will not be shared wider than the group of people who are all invited to attend this evening. We'll go through our panel speakers session, which will take perhaps half an hour or so. Please be thinking of your questions during that. If you do have a question, can you please write it in the Q&A rather than the chat function? You'll see that at the bottom of the screen. And once we have the questions starting to come through there, I will direct those to our panelists. And you will see those questions as we make them live. You won't see them until we click on those for you, but rest assured we'll be seeing your questions as they come through. If anyone does have any technical difficulties, you can use the chat function to tell us about those, although I'm not entirely sure I'll be able to do anything about it, but please keep the chat function free for those kinds of difficulties. As I said, we have a number of Working Party members on the call with us this evening. If you would like to, Working Party members, contribute some comment or discussion yourselves, because of course you have all been part of this piece of work, please use the raise your hand function and I can unmute your microphone or give you the microphone, as it were, and we can hear your contribution rather than just asking a question. Because of course, if you were in the room, you would be able to do that freely. So without further ado, let me hand over to Sir Robert to tell us about the report.
Thank you, Jodie, very much. If my voice sounds a little faint, it's because I've recently had to have some surgery to my neck, but I apologize in advance and I hope you'll be able to hear me. The Working Party that produced the report published today was convened in June 2019, just over a year ago. The immediate trigger for the decision to convene the Working Party was the response of bereaved and survivors to the establishment of the inquiry into the Grenfell Tower disaster, which demonstrated yet again the erosion of confidence in the response of the justice system to deaths giving rise to public concern. That's to say, incidents causing multiple fatalities or single deaths arising from a pattern of systemic failure. The report is also timely in the light of the acknowledgement by Her Majesty's government of the need for a public inquiry in due course into the management of the coronavirus pandemic. I'm sure it's common ground that the public, and in particular the bereaved and survivors of such major incidents or sequence of deaths, are entitled to know what happened, why it happened, and what can be done to prevent it happening again. And if it is to enjoy the confidence of the public, the justice system must provide a means of answering those questions, a means that is consistent, open, timely, coherent, and readily understandable. Our initial focus was on addressing the related and widely recognized issues of delay and duplication that frankly have plagued the current arrangements for the investigation of major incidents. But it soon became clear that the scope of the project should be expanded to a comprehensive review of the failings of the current arrangements and consideration of the ways in which they can be remedied. Our recommendations build on the strengths of the present system. We're not recommending radical change, but we seek to address the many shortcomings, and we are confident that our recommendations, if implemented, will restore public confidence in the way in which the justice system responds to such events. We make a total of 52 detailed recommendations, but by way of introduction, I propose simply to focus on some that are of particular importance. As to public inquiries, we strongly recommend the development of a dedicated central inquiries unit within the Cabinet Office. At present, there is simply no central repository of experience in the establishment and running of public inquiries. Such a unit will fill that void and can serve as a source of advice to inquiry secretariats on best practice. It can also conduct procurement exercises for the physical and digital infrastructure of inquiries. And we are confident that the establishment of such a unit can contribute to the reduction of delay and to substantial savings. At present, inquiries frankly start from scratch, save insofar as they're able to benefit from word of mouth advice from those with past experience. We also recommend in this context that the unit be supplemented by an independent advisory board to advise on the appointment of inquiry chairs and panels, and that in the interests of transparency, reinforcing the confidence of the public, it should include representation from the bereaved and survivors of catastrophic events. As to inquests, we propose the establishment of a new special procedure inquest to sit between a full-blown public inquiry and a standard inquest. You can see the detail of what we propose in recommendation 11 and the following paragraphs. The proposed procedure, for the development of which we are indebted to Sir Peter Thornton, the first Chief Coroner, is set out in detail in the annex to our report. Essentially, we see it as filling the gap between cases in which the government decides that it is not appropriate to hold a public inquiry, and yet the death or sequence of deaths gives rise to a legitimate public concern. The proposed structure is set out in detail in the annex to the report. The important point is that the special procedure inquest will give clarity and certainty at a very early stage as to what is to happen in the event of an incident causing multiple fatalities or a death which, by reference to other death or deaths, gives rise to issues of systemic failure. We consider that if adopted, it is likely to reduce both the number of public inquiries and, perhaps as importantly, calls for them to be set up. The public will know exactly where they stand from the outset. The introduction of the special procedure will impose a further burden on the Chief Coroner, and for that and other reasons set out in our report, we join the call that has been made on a number of occasions for the office of the Chief Coroner to be made a full-time appointment. The duty of candour. Institutional defensiveness on the part of state and corporate interested parties at inquests or core participants in inquiries is invariably cited as a cause of further suffering to the bereaved or survivors. A number of reports have highlighted institutional defensiveness in Article 2 investigations. In her review of deaths and serious incidents in police custody, Dame Eilish Aglioni concluded, and I quote, "It is clear that the default position whenever there is a death or serious incident involving the police tends to be one of defensiveness on the part of state bodies." The problem was also highlighted by Bishop Jones in his report, tellingly entitled "The Patronizing Disposition of Unaccountable Power," in which he promulgated a charter directed at the voluntary adoption of such a duty. There can be little doubt that institutional defensiveness and an adversarial approach to such proceedings has a detrimental impact on participation and public confidence and can impede the effectiveness of an inquiry or an inquest. Such a stance also contributes to lengthy delay as the inquiry attempts to grapple with identifying and resolving the issues in dispute. In the administrative division of the High Court, a public authority must assist the court with full and accurate explanations of all the facts relevant to the issue before the court, including information that is harmful to its own case. Furthermore, and as a result of the recommendations arising from the Mid-Staffordshire NHS Foundation Trust, public inquiry, statutory duties of candour have been introduced in the health sector. There is no reason why such a duty should not apply to inquests and inquiries. We make two recommendations. First, we recommend that the leaders of all public bodies sign up to the charter promulgated by Bishop Jones. But it is noteworthy that only one of the bodies involved in the Grenville inquiry has done so. And the voluntary nature of the charter means that it does not provide the panacea. In 2016 to 2017, a bill, the Public Authority Accountability Bill, was introduced with cross-party support. If enacted, it would have introduced a statutory duty of candour, but the bill fell after the 2017 general election. The time has undoubtedly come for introduction of a statutory duty of candour in inquests and inquiries, to include a rebuttable requirement of position statements at the outset of proceedings, and subject only to the privilege against self-incrimination. Not only will its enactment go a long way to the restoration of public confidence, but the discharge of such a duty will undoubtedly speed proceedings and reduce delay and cost. It will also go a considerable way to ending the adversarial approach to inquisitorial proceedings directed at establishing the facts. Next, a word about public engagement and the barriers to effective participation. Many of our recommendations address the issue of engagement with the public, and in particular, the bereaved and survivors of a disaster. We regard this as of high importance. One aspect of the problem was graphically illustrated by an account that we heard of the first hearing of an inquest, in which the bereaved were faced by the backs of a phalanx of lawyers arguing the applicability of Article 2 of the ECHR. Mumbo jumbo to the bereaved and alienating. This is not untypical. Lip service is often paid to putting the bereaved or survivors at the center of proceedings, and in some cases this is done, notably in the infected blood inquiry. But in reality, it is often no more than lip service. Whether it is an inquiry or an inquest, and at a time when they may be deeply distressed, the bereaved will be facing a situation with which they are wholly unfamiliar. They may be bewildered and intimidated by their surroundings. They may not understand what is going on. But there is much that can be done. We make a large number of recommendations, many of which relate to communication. The bereaved or survivors must be kept fully informed as to what is happening, as to what is going to happen next, why there's been a delay, what their rights are and what part they can play. It also involves careful thought about the location of hearings and the layout of hearing premises. And other recommendations relate to the need for sensitivities, to the vulnerability of interested parties, core participants and witnesses to enable them to participate effectively. We also make a recommendation as to funding for representation. The final principal area of our recommendations that I'd like to mention at this stage is the question of accountability and systemic change. All too often, recommendations made by inquiries are lost in the long grass. We make specific recommendations for tracking the steps taken by those to whom recommendations are addressed. We further support proposals for the establishment of an independent body charged with monitoring the implementation and effectiveness of recommendations. And in this context, we also see an important role for the liaison committee in Parliament that steers the work of parliamentary select committees. It can assist them in scrutinizing the implementation of inquiry findings and holding ministers to account. That is all that I propose to say at this stage as to our recommendations. But I would personally like to pay tribute to the members of the Working Party and of the subgroups. They represented a simply outstanding wealth of relevant experience and specialist expertise. Experience in setting up and running public inquiries, experience in conducting inquests in cases of major fatalities, experience as advocates before inquiries and inquests, experience in representing the interests of the bereaved and survivors, and also those who were able to give an insight from the academic perspective. As Jodie has already said, it was a group distinguished by their practical experience, but also by the willingness to give up their time unstintingly to assist us in our deliberations. Their combined experience gives weight and authority to our recommendations. I should like to pay tribute in particular to those who chaired the 4 subgroups: Sir John Goldring, who of course presided over the renewed Hillsborough inquests; Deborah Coles, the Chief Executive of Inquest; Martin Smith, currently Solicitor to the Independent Inquiry into Child Sexual Abuse and with vast experience of major public inquiries; and Ken Sutton, the Director of the Hillsborough Panel and currently Secretary to the Kent Maternity Services Independent Investigation. I should also like to pay tribute to the many, many people listed in our report who shared their time and experience with us, in particular to the Right Honourable Dame Eilish Angiolini and to the Right Reverend Bishop Jones, in the footsteps of both of whom we trod, and to the bereaved family members who generously shared with us their lived experience of the system. My thanks are due to Sonia van der Graaf and her team from Morrison Forster, who undertook valuable research for us and provided us with accommodation, as Jodie has mentioned, until lockdown intervened. And I cannot let this opportunity pass without expressing my immense debt to the guidance and support of the Justice team, to Jodie, a legal director, and very much to Robbie Stern, the senior legal fellow. Jodie, thank you.
Thank you so much, Robert. My apologies for dropping off myself there. It's the first time ever my internet connection has gone down, and what a time to choose it.
Yes.
It's back. It seems to be working now, fortunately. And I don't have any of your problems down in Cornwall, so I can't understand at all what the reason for that was. It's been a day of technical difficulties, but we seem to be getting through. So without any further ado, I will pass over to Jason, please, for any thoughts and comments that you might have. Thank you.
Thanks very much, Jodie. Evening, everyone. I wanted, if I could, to bring a little historical perspective to what I think is the centerpiece of the report. That's not to elevate one part of the report above others, because they're all equally important. But from my perspective, the centerpiece is the creation of the Special Procedure Inquest. It stands out. Now, periodically over the past 20 years or so, commentators have suggested that the utility of public inquiries would be increased if they were to combine with civil, criminal, disciplinary, and inquisitorial proceedings. And that view has been in part informed by a perception that after a serious disaster, particularly one involving the loss of many lives, the public expectation is that the inquiry will establish whether any person or organisation should be held criminally responsible or civilly liable. And of course, it's both logical and natural that decisions on similar or related issues based on the same or similar evidence obtained from an investigation about the same events should be taken by one as opposed to more than one person or body. After all, repetition's likely to cause delay. It's likely to create additional anxiety and distress, particularly for bereaved and survivors. Not mention and the real possibility of the inconsistency of outcomes. But the difficulty of reducing parallel or even overlapping procedures and instead unifying them arises, it seems, from the pursuit of the public interests involved in each of the presently separate proceedings. And so, although the reasons for instituting a public inquiry are often numerous and complex, the most important amongst them are often to ascertain the facts, to recommend changes, to reduce the risk of recurrence. Whereas the primary purpose that is pursued in criminal proceedings is, by contrast, the attribution of culpability and, if appropriate, the imposition of punishment. And so previous proposals to unify proceedings have, I'm sad to say, failed to gather any sufficient momentum. So back in 1989, Stephen Sedley, then in Silk, suggested that in addition to fulfilling the classic task of meeting public concern with official concern, inquiries are capable of performing a further task openly and judicially, but with much fuller and fresher evidence than a court of law ever enjoys, and that's the apportionment of legal blame. He asked rhetorically, is there not a case for legislation that would invest particular judicial public inquiries with powers of legal adjudication? In 1998, Derry Irvine, the then Lord Chancellor, drew attention to the multiplicity of proceedings arising from inquiries into financial disasters. He advanced the possibility of a single set of proceedings responsible for not only hearing criminal charges, but for producing reports along the lines of the Companies Act and Financial Services Act investigations. Responding to that suggestion, a working group on financial regulation was set up by the Society for Advanced Legal Studies. The working group was chaired by George Staples QC, but its report concluded that the benefit of any integration was outweighed by consequent disadvantages. Lord Justice Auld, in his review into the criminal courts of England and Wales, said he didn't think much of the reasons given for that conclusion. The most extensive review, before today that is, as to whether such combination could occur, and if so, whether such combination of proceedings was a desirable aim, was conducted by Sir Roy Beldam and Judith Bernstein in their 2002 review of inquiries and overlapping procedures. They noted the following three main difficulties with the approach of combination. First, the potential conflict with some parts of Article 6 of the Convention. Second, the potential for compromising the inquisitorial nature of inquiry proceedings, thereby risking the achievement of other aims of such inquiries, adding to their length, complexity, and cost. In short, if the purpose of the inquiry was extended to determine issues of criminal or civil liability, that inquisitorial approach would inevitably be lost. And third, the potential that by holding inquiry hearings in public and being unable to inform witnesses that the evidence that they gave to the inquiry wouldn't be used against them in any criminal proceedings, inquiries would have at their disposal less and not more evidence. So it's against that background that the Justice Report concludes, I think, that the balance between the fair trial rights of an accused and the state's responsibility, its obligations, to conduct an adequate, independent, prompt, and transparent investigation. That means that to some extent, the problem of multiple processes is, to quote the report, intractable. And therefore, it doesn't recommend, rightly in my view, what Lord Justice Clark once described as the creation of a disaster court, which would find the facts, which would make recommendations, and which would also establish civil and criminal liability. And so instead, the bundle of measures proposed in this report comes as close as possible to addressing the harms identified in the report without the creation of the so-called disaster court. As I've said, at the centre of them, as I see it, is the creation of the special procedure inquest. for investigating mass fatalities as well as single deaths linked by systemic failure, able to consider closed material and make specific recommendations to prevent reoccurrence. This proposal is more modest than the disaster court previously contemplated, but it's well achievable and it's necessary. Having been involved in many inquests and inquiries over the past 25 years, it's often struck me personally that there needed to be a hybrid procedure that sat between the poles of an inquest on the one hand and the inquiry on the other. And the special procedure inquest does exactly that. It's a proposal, therefore, that I would wholeheartedly welcome and support. And I, speaking for myself, look forward to seeing a more positive response to it than has been the case in response to past proposals. But with that focus on a limited aspect of this great report, can I hand over to Alison?
Thank you very much, Jason. And thank you to Justice for inviting me to the discussion panel and the launch webinar. I'm delighted to be here amongst you all. I'd like to echo what's been said and endorse what's been said by the panelists so far. I do feel something of an advantage, however, because I've had the benefit of the fact that a number of my exceptional colleagues in chambers, in particular Professor Leslie Thomas QC, Thalia Marag and Una Morris, all of Garden Court Chambers, were all members of the working group, so of course, and the working party. So of course, through discussions with them over the past year, I've had an insight into some of the discussions that you've been having, the issues that the working party were grappling with, and importantly, the breadth of its ambition and its hopes. Having now had an opportunity to read through the report, I can see the tremendous amount of work and efforts that have been put into producing this document. And I really would like to thank those three individuals for their particular expertise they brought to and their practical knowledge that they brought to bear with great benefit to the working party, as well as all the judicial and lay members of the party, some of whom I've had the pleasure of knowing through my own practice, in particular people such as John Goldring, who was of course a coroner on Hillsborough, when I was lucky enough to represent a number of the bereaved families, and the organisation Inquest, which for many years has been a source of great, an invaluable source of great resources and advice and help to those of us who practice in the field of inquests and represent families, and also an incredibly effective and important campaigning organisation under the direction and leadership of the amazing Deb Coles. The report is far-reaching and I think it's bold. One now hopes, though, that those with the power and the authority to actually implement the recommendations share that boldness and that level of commitment, because these recommendations are long overdue. Just obviously in the limited time that we all have, I just wanted to perhaps pick out a few of the pointers and a few of the recommendations that particularly resonated with me as a practitioner and I thought were particularly important. It's already been touched upon, the question of effective participation. That is something that has become a bit of a mantra for bereaved families, both in inquests and public inquiries, because it really is at the heart of many of the concerns and difficulties they have with the system. We are dealing with people who are already traumatized, they're in grief, they're suffering, and they want answers as to how their loved one died and the particular circumstances. And what they're often faced with, as the report very neatly and very well illustrates, is a bewildering world of inquests and public inquiries, where they often feel sidelined and, you know, demoted to the role of bystanders to their own tragedies, and certainly don't feel at the centre of the proceedings. I mean, obviously in different scenarios, different inquiries, different inquests, what effective participation look like does vary, but there are certain common threads which we've found, certainly in my practice and speaking to many families, bereaved families, is that one, people want to be heard. They want to feel that they are actually being listened to, because it's one thing, you know, being faced with a public body, being faced with judges, being faced with lawyers who are saying, yes, 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 we hear you. But are you actually listening to these individuals, to these families? So they want to feel that they are being listened to. They want to feel that their concerns are being taken seriously. They want to feel that there's a resolution and that lessons are learned. Also, and I want to just, perhaps it may be a bit of a sideline here, I don't think it is, I think it's quite integral, just mention something else at this point, diversity. Not because it's topical or trendy at the moment, but because it's important and always has been. And I think those of us, again, who work in the areas of inquests and public inquiries have been very much aware of this and recognised and alive to this for many, many years. And it's good that slowly but surely other people are catching up. But we need to keep the momentum going there. But often these disasters, not obviously exclusively, but very often, disasters, big disasters, deaths in custody, shootings, etc., disproportionately impact working class communities and those most disadvantaged in society, the poorest in society. And then when one looks further, amongst those working class communities, those disadvantaged communities, again, disproportionately, Black and brown people are represented within those communities. Recent immigrants, other minority peoples. Just looking at the two, one huge inquest and one big public inquiry that I've had the benefit and privilege of being involved with on behalf of bereaved families. Hillsborough was and is predominantly those who were affected working class peoples. Football, despite the costs nowadays and the gentrification of the game, back in 1989, very much was still a working class game supported primarily by working class people, and they were the ones who were affected directly. Grenfell, now we're looking at its social housing. It's one of the richest boroughs in the country, and who was affected? Not those in the lovely houses in South Ken, but those in social housing, and again, predominantly it was, many of those affected were from ethnic minority backgrounds. So these are issues that have always been there and really do need to be grappled with. And I would commend to those who hadn't read it or seen it, Leslie Thomas QC, Professor Thomas made some very trenchant submissions very recently to the Grenfell inquiry on the very question of diversity, discrimination, race and class, and they really do resonate, and I would highly recommend people either read them or view them on the Grenfell website. So with that context in mind, the sort of four areas that I particularly stood out for me were duty of candour. As has already been said, I've often found that inquests, for example, which are supposed to be inquisitorial, are far more adversarial than any criminal cases that I ever do, because you are faced with public bodies who approach them from very much a defensive perspective, rather than, and see themselves as litigants who are fighting their position, rather than coming to an inquest or a public inquiry in order to find the truth and to provide information. So, as has already been said, the work that has been done on the question of duty of candour from Bishop James and Pete Weatherby in particular, because this has been something that Pete has been really pushing for many, many years now, is vitally important. And having a statutory duty of candour, I see that as an essential prerequisite to any investigative process. With public inquiries, the whole issue of questioning of witnesses, Rule 10, for example, and how that has evolved, or not as the case may be, is something that, again, is a bit of a mantra for many of our families. It's something that has come up repeatedly on Grenfell as a theme. But what one finds when one looks at how the approach to questioning witnesses is dealt with in public inquiries, as with many other aspects presently of public inquiries, it's very much dependent on the approach taken by an individual chair or the individual CTI on different inquiries. So again, it very much chimes in with the themes of the report about the way in which matters have been approached thus far, both in the arenas of inquest, but also public inquiries, in a not quite an ad hoc manner, but there's been a lack of statutory and protocols and statutory involvement, which is much needed, so that there is some sort of uniform approach across the country, as opposed to the situation we have now where, as I say, with public inquiries, it very much depends on the approach of the individual chair, panel members, CTI. With inquests, it depends on your local coroner. You can literally go from one area to another and have completely different approaches. I'm sure we've all encountered that in cases where a senior coroner in one area will be very open to issues about disclosure and very open to issues about having proper PTRs and case management. You go to the next, literally the neighbouring area, and do an inquest, and you have a completely different experience. And that is something that particularly frustrates families. Funding of inquests is something that has been, again, a bone of contention and a very difficult area for many bereaved families. I recall when I first started out as a pupil and a junior barrister in the 1990s, it was routine for solicitors to ask you to do pro bono inquests, sometimes quite complex inquests, pro bono or for very limited funding. And off you'd go to the four corners of the jurisdiction with your return rail ticket, a tiny piece of disclosure and and the goodwill of your instructing solicitor and hoping for the best. Things have moved on hugely since then, but on the question of funding, we still are at a situation where there are many instances, and I've had that quite recently, where families are simply refused funding and either have to hope that inquest and those lawyers who are involved in inquest will represent them pro bono, or that there's some other means, because otherwise they are left high and dry. And so that remains a huge area that really needs to be tackled. And finally, the question of lessons to be learned. Historical events, and I say this as somebody who actually did a history degree, so it always amazes me that how historical events are treated. They're not simply there as something that happened in the past. Very often they are there so that we can learn from them. So mistakes are not made again, so that warning signs are seen and acted upon, and so that better practices can be put in place. Sadly, we know all too well that when it comes to disasters, history simply repeats itself again and again and again. This is something that the families on Grenfell have said. It's something that is coming out of the evidence. Perhaps a very stark example of that was in phase 1. The body cam footage from a police officer recorded a meeting that was happening in the early hours of the morning on the fire. A meeting involved with all the emergency agencies, the fire brigade, the police, ambulance services. Senior officers were all there. And one senior officer made a comment about Lacanau. And let's not, make sure we're not, falling into the trap of Lacanau. It was all too late. Lacanau was a fire that had happened several years before. No one seemed to have learned. There was, there was an inquest, recommendations were made. What was learned? Sadly, nothing. And that is something that many of our families say in inquests and in public inquiries. They're not after retribution. They're not after money. They want truth, they want justice, but they also want to make sure that these things don't happen to other families in the future and the lessons are learned. So I'm really heartened that the report has looked at those areas and really sort of put forward some trenchant and practical ways of addressing those. As I said, the battle now and the struggle now is to make sure that those are implemented by the powers that be, and that they, as I say, have the boldness and the foresight that we've seen from the Working Party and the recommendations that have come out from the report. Thank you. And I think it's my job now to hand over the baton to Ken. Oh, Ken, you're muted, so you need to unmute yourself.
Thank you. It may be concerning to you, Robert and Jodie, to hear that I've decided not to say what I plan to say, because what's already been said by you, Robert, Jason and Alison, is so eloquent that I think it would be more helpful if I tried to add some extra to it than merely agree with what's been said. My first point with that in mind is that mention has been made of my involvement in Hillsborough and other inquiries, but I was also involved for over 30 years in senior positions in the Home Office. And I think what I can say from that is that that also brings with it evidence of the need for the Working Party's recommendations, because the issue of institutional defensiveness I have seen from the inside, and it gives me no pleasure that after now over 40 years of working with these issues, that what's being recommended is essential. And in my judgment, the issues that the Working Party is addressing amount to a national scandal. And aspects of that have been described by you, Robert, and by Alison. It's a scandal because, by definition, public confidence of those most affected will have been lost by the time that there's any inquest or inquiry. David Cameron, in the context of responding to the Hillsborough Independent Panel report, described a double injustice affecting the Hillsborough families. And that double injustice is present on every occasion because the trust of those involved has already been lost, and it is beholden upon the authorities concerned, who are able to do this, to help to restore public confidence by making sure that when things go wrong, the processes are fair and effectively engage those most concerned. I was pleased, Robert, that you referred to the issue of cost. And the reason I'm pleased about that is that while those of us who are clear about these issues will see the context of the pandemic and the forthcoming inquiry as making our recommendations timely, I think there is a danger that the context of the pandemic will be, in practice, used as a way of dismissing issues, even these, which, as I say, amount to a national scandal. And I think if we are to meet that risk, then we have to be able to demonstrate, as your remarks did, Robert, that these proposals do not in total involve an impossible increase in public expenditure. And the reason why that's that we're vulnerable to that argument, but it's a false argument, is that it is assumed that any costs of what you described, Alison, I think in bold changes, must be in addition to the costs that are already involved. And that is patently not the case. If you take one of my special areas of interest in relation to candour, I know for a fact that the costs which are incurred by a lack of candour will far outstrip the costs which are involved in providing the proper mechanisms to ensure engagement of those affected when things go wrong. I know that. And I think it's part of our task now to demonstrate that these proposals cannot and should not be dismissed on the basis of cost. I want to just say one or two things about, more specifically, about the recommendations. Firstly, in relation to candour, I have, with some reluctance, concluded, as you suggested in your remarks, Robert, that the charter which we, with Bishop Jones, we advocated in patronising disposition is not a panacea. And the reason I've come to that conclusion is that I think it is essential for those working within organisations to know that if something does go wrong, and that there is a possibility of an inquiry, not even a certainty, a possibility of an inquiry, then there will be a requirement, a statutory requirement of candour. And I think we shouldn't underestimate the impact that that would have upstream, as it were, within those organisations. If sometimes more junior members of staff are aware that their organisation will be required to be candid, I think some of the problems of institutional defensiveness can be avoided, as it were, before they start, not merely corrected at the point of the inquiry. On this theme of costs, just to add to what you were saying, Robert, I think the creation of a stronger central unit with an independent advisory element would mean that the nugatory costs, which I've seen probably personally demonstrated, the nugatory costs which are occurred when inquiries are established can be rationalised and avoided. It can also mean that in that critical period, when those most affected are looking for the processes of inquiry to restore confidence, to begin to find answers, what in practice they find is that the inquiries are spending months, if not years, getting organised in order to deliver that task, by which time there is a further loss of confidence. And then finally, and again with some reluctance, I'm driven to the conclusion that some form of independent mechanism is necessary to make sure that the lessons are learnt. You exposed this a moment ago, Alison, very, very eloquently. And I can tell you that the public will no longer tolerate the failure to learn lessons. And in every discussion, every encounter I have, this is now the number one point of criticism. It is no longer acceptable that the lessons which are inherent in previous tragedies are not learnt. And reluctantly, I think that means that there has to be a body persistently tracking and prompting those lessons. By definition, the particular inquiries are not there at that point to do so. And the evidence over in my experience now 40 years is that you cannot rely upon the insiders in the system to implement recommendations once they've been made. So I hope that's helpful. I'm not quite sure, Jodie, whose responsibility it is to go next, but I'm sure you'll put us straight.
Indeed. Thank you, Ken. We are at the end of the panel, so you can't pass on to anyone else unless we all went round again, which I don't think we need to, because thank you all so much for your support in your comments and your thoughtful and helpful considerations of where the problems lie, with which I think we at Justice would agree and the Working Party members would agree, and indeed these are the problems we have been grappling with over the past year.
Firstly, I'd like to thank Sir Robert, Jason, Alison and Ken for speaking at the launch tonight and for bringing this work and the importance of reform to life. Thanks also to all of you for your questions and comments. At Justice, we focus on the fair administration of justice, on procedure and procedural fairness. And there's a view that procedure is sort of unimportant compared to substantive law, that it's dry, it's legalistic. But procedure matters, and it's central to the way justice is delivered. It's what allows for access to justice, for interrogation of evidence, for the uncovering of truth. And when it works well, it allows people to feel heard and included, and to feel that the courts are their courts. And when it fails, they feel, and they're right to feel, excluded and marginalised and discriminated against in the way that Alison describes. I think this report shows the importance of procedure and of getting it right in response to tragedy. Public trust and confidence demand reform for what Ken and Alison have agreed is a national scandal. And with a public inquiry on the government's handling of coronavirus in the offing, this seems to be sort of all the more important and timely. So my huge thanks to the panel for their work tonight. Obviously, a lot's gone in to make this report come to being, and our thanks to Sir Robert for his leadership of the Working Party. It was a large and despite 3 members being from Garden Court Chambers, a diverse group of our members and experts from across the field. And Sir Robert has brought everyone together with common purpose and shared with great wisdom. My huge thanks to the Working Party and subgroup members for their hard work, for their time and for their insights, and for being flexible, because partway through we obviously had to adjust to the realities of coronavirus. Our particular thanks to Sonia and her team at MoFo for their support. I only wish that we were all in their beautiful offices tonight with a glass of wine, but that is not to be. And again, thanks to Justices Robbie Stern and to Jodie, along with our amazing interns for their work on the report. Finally, we took a lot of evidence for this report, including from bereaved family members, and we're especially grateful to them for sharing with us. Tonight, we mark the completion of the report, but it's the beginning of the more challenging phase of implementation of the Working Party's report. And as tonight's discussions highlighted, it's not going to be easy. We look forward to working with all of you to push for meaningful change. And I'd encourage you to please get in touch with any ideas about things you think we should do, people we should talk to in order to see this change effected. And Justice's work continues. After a year of work, our next Working Party report, chaired by Sandra Paul, is going to be launched in November. It focuses on racial disparity in the youth justice system. And before then, Lord Dyson will be leading an advisory group of our members, guiding our response to the recently announced independent review on administrative law, which raises the possibility of significant change to judicial review. So we have a very busy summer ahead. I'd like to thank you all for joining us tonight. I'd like to, and I hope that the remainder of your summer is happy and safe. And we look forward to being in touch later in the year. Thank you and good night. And let's remotely just all clap for our panel. Thank you. It's ridiculous, but there we go. Good night, everybody, and thank you.
Good night, Andrea.